The first question in any summary judgment motion is whether it's worth making. Summary judgment is expensive. It takes a lot of billable hours to comb through the discovery record, put together statements of fact, do the legal research, and write the affidavits and briefs. And of course, the summary judgment standard is a high bar. It's actually a higher burden to win on summary judgment than at trial. At trial, you have to prove your case by a preponderance of the evidence, which means 51%. For summary judgment, you have to show that no rational jury could find for the other side. On top of that, it's a discretionary motion, so even if you satisfy the legal standard, the court could decide to deny the motion anyway. There are certain strategies for summary judgment briefing that apply whether you're moving or opposing a motion. One is to review the evidence before you map out your argument. If you draft first and then look for evidence to back up your points, you may leave out an important document or realize an argument just doesn't work. Or you could miss a good argument altogether. Remember that all evidence you rely on must be admissible. Think through possible evidentiary objections and whether you can overcome them. In an affidavit attaching exhibits, lay the foundation for admissibility for each document. And for facts substantiated by affidavits, specify how the witnesses have personal knowledge. Cite the other side's evidence as much as possible. Relying mostly on your own evidence will seem self-serving and less credible. A simple and powerful way to show consensus on a factual point is to have a parallel citation to both parties' evidence. It's also effective to rely on testimony from the other side's witnesses. You can play it up, like, even the plaintiff's lead salesperson had to concede that sales never approached the targets. Contemporaneous documents are often the most persuasive evidence, rather than discovery created for the litigation. The judge is more likely to give weight to an email written long before the lawsuit than to deposition testimony. If you need to rely on testimony, try to lead with what a contemporaneous document says, and then use the testimony to bolster the point. Affidavits are an underutilized form of evidence because lawyers treat them like an afterthought. Draft affidavits with care and don't leave them for the last minute. Summary judgment affidavits are offered in lieu of trial testimony, so make them sound like spoken testimony, where the witness tells the whole story, rather than just reciting disjointed facts. As far as your legal research, be sure to review summary judgment decisions from your judge. Even their decisions on other types of claims can be useful, because you can learn what kinds of arguments they find persuasive and then draw analogies. Say your judge focuses on expert reports a lot. You'd want to include arguments that feature your expert and quote cases from your judge that support your outcome, like a prior case that rejected summary judgment based on an expert report. Besides case law, another good resource for authority is the pattern jury instructions. They'll help you focus your argument on the questions the jury would need to answer. When you draft the legal standard, remember that the judge decides these motions routinely, so keep it short. And rather than copy-pasting the same cases from some other summary judgment brief, be deliberate in choosing cases that support your arguments. For example, if your main argument is that there are too many factual issues to decide the case at summary judgment, you could quote a case that says, "Where complicated evidentiary issues permeate the case, such questions must be resolved by the jury, not the judge." This explains the standard in a way that reinforces your argument.